5 seconds. In the meanwhile, civil writ petition number 17404 was filed by the first respondent before the High Court of Punjab and Haryana at Chandigarh, invoking Articles 226, 227 of the Constitution for amendments to the Union of India. The Chief Justice of Punjab and Haryana High Court, State of Haryana, and Department of Consumer Affairs, State of Haryana, to follow the procedure as laid down in Section 16 of the Consumer Protection Act in its letter and spirit for the appointment of the President of the State Commission. Another writ petition CWP number 17-26203, which had been filed earlier by one Dharmendra Singh Rawat, advocate, on the connected subject of initiation of the proposal, was heard along with CWP number 17404 filed by the first respondent. The High Court, by a common judgment, allowed the two writ petitions and made appropriate directions to the state government therein. The High Court followed the decision of this court in Assis Handa Supra, which held the filed at the material time, by taking the view that the process of consultation contemplated under Section 16(1)(a) of the Act was almost identical to the process of consultation required under Article 217 of the Constitution. The High Court upheld the appointment of Justice M.R. Agnihotri, a retired judge of the High Court, as the President of the State Commission, as communicated by the Registrar of the High Court to the Haryana government on 10/6/1994. Finding that there was substantial compliance with Section 16(1)(a) of the Act, the appointment of Justice Agnihotri was upheld, and the writ petition challenging his appointment was dismissed on the question of interpretation of the newly introduced Section 16(1)(a). The High Court was of the view that there was no conflict between the provisions of Section 16(1)(a) and 16(1)(a) of the Act, as they could effectively operate in their respective fields which did not overlap. The High Court was further of the view that the provisions of Section 16(1)(a) would have hardly any, much less an effective role in the appointment of the President of the State Commission in terms of Section 16(1)(a), and the selection committee contemplated by Section 16(1)(a) could not be utilized for the selection of the President, for which a separate provision was made under Section 16(1)(a). The writ petition was accordingly allowed and appropriate directions were issued.